ma'am. Injustice anywhere is a threat to justice everywhere. Martin Luther King Jr. said this. Dear participants, good evening everyone, and a warm welcome to this enlightening session on the ironical protection regime of displaced persons in India. Today, we gathered here to delve into the critical discourse led by a distinguished advocate for human rights, especially for those displaced by historical and contemporary challenges. It is my privilege to introduce Dr. Priya Gupta, a luminary in the realm of human rights activism, particularly focusing on the rights of displaced populations in Jammu and Kashmir. Ma'am's journey is marked by an unwavering commitment to the principles of justice and equality. Armed with a formidable academic background, holding a BA, LLB, LLM, and PhD in law, she has devoted over a decade to studying and advocating for the rights of West Pakistan refugees in the context of Article 370 of the Indian Constitution. Dr. Priya Gupta expertise transcends mere academic rigor. It resonates in her practical efforts and extensive advocacy work. She's championed the cause of marginalized communities, including women and displaced persons, through numerous national and international platforms. And her scholarly contributions include her academic book titled Alienation of West Pakistan Refugees and Article 370 of the Indian Constitution, which underscores her profound understanding of the intricate legal and humanitarian dimensions of displacement. Today, we are honored to have ma'am with us to provide us insights into the ironical protection regime faced by displaced persons in India. Her perspectives promise us to enrich us with the understanding and ignite our collective commitments to human rights. Over to you, ma'am.
Thank you, Pooja. Thank you so much. So, good evening, everybody. Am I audible to all of you?
Yes, ma'am.
Yes,
Okay.
ma'am,
Okay.
you're audible.
Okay, let me begin then. So, good evening, everybody. Today, we are going to delve more on the subject that is ironical protection regime of the displaced persons in India. Well, why ironical? This we are going to learn in the upcoming lecture. So, before we delve more into the subject. It is very important for us to understand this entire phenomena of displacements. Now, displacements as an entire phenomena has been such which has been existent, since the inception of the human civilization. You go back to any dispute that happened in the past, and the ultimate consequence would be the displacements of persons from one part of the world to another part of the world. Let's say you go back to World War I or to the World War II. There were so many displacements that happened, and ultimately leading the entire world to ponder more upon the subject of refugees and the displacements because of the consequences that they had to undergo, some serious repercussions that they had to undergo. And again, we might have heard, all of us might have heard about the horrific stories in the past after the partition of India in 1947 from our ancestors. What it takes and how these people were displaced. There was mass influx on both sides of the border. And if we look at the contemporary aspect, we can see what is happening in Iran, Iraq, where there are so many genocides happening, and in other parts of the world where again displacements are still persistent and these people are suffering. If you look back, and if many of you might have even heard of stories of displacements from your ancestors, it is they actually face very serious repercussions, where they are not only saving their lives, where there is not only a toll on their lives, but in the entire process of getting uprooted from one place and suddenly going to any other part of the world, there are heavy losses that they have to face. Sometimes, my grandmother, she used to tell me. During the displacement of 1947, what these guys had undergone, because it is not only the sustenance of their lives, but they leave behind all their movable and immovable properties. They leave behind all their unaccounted bank balances, and on their way to go to a place where they find themselves safe. They have to undergo and they have to see so many atrocities where there is slaughtering of the children in front of their parents, and slaughtering of parents in front of their children, and then systematized rapes, ravishment of the women, robbery, dacoity, and whatnot. So I think that, and above that, their atrocities and their miseries, they do not end here. when ultimately they land themselves in any particular land where they think that they are safe, they ultimately have to face sometimes a hostile behavior from the receiving state, because not every receiving state is very welcoming to these people. Sometimes they have xenophobic tendencies from the local population, which is not ready to accept them. Sometimes the states are not ready to accept them, given the turpitudes or the social turpitudes that these states are already facing. For instance, let's say about the unemployment or the poverty or overpopulation, such a state is going. So it would definitely not welcome such aliens to its state, which again would be the responsibility of the state to manage. And if we look at the local residents, they would also not, like to invite somebody who's going to share their portion of employment or land. Or so we do have such tendencies where the local residents are not at all ready to accept such people. So but that is what I'm trying to tell you, that the miseries of these people are multi-tier. It is not only that they are being uprooted from one place and they have, moved to any other part of the world. It is also that sometimes they are not quite welcomed. Now, the attitudes of different countries and different governments of the entire global community, they vary. While, some may be very welcoming to these displaced persons. For instance, if we have the US or Canada or Netherlands or Switzerland or the entire African continent, they are very well reputed for intaking the refugees and managing and catering to their needs. On the other hand, we have countries like the Western Balkans, or we have the Germans, or Greece, where such countries, they do not find themselves to be pretty obligated to cater to the needs of these people. Uh, and so that is how, and whenever we talk about the protection of these displaced persons, it is always a very discretionary matter. Discretionary in the sense that every government, it exercises its discretionary power, whether depending upon its own governmental policies or its own affinity with the community that is entering their country, or from the place from which they are coming, depending upon their relationships, their bilateral agreements, etc. The government, actually is quite discretionary in providing displacement, or in providing refuge to one class of displacement, while it might not be providing refuge to any other class of the displacements. What exactly happens is, when these displaced persons, they enter a particular territory, so they most of the countries, they have a very well defined structure as to how to register these people, so that every government, it knows as to what is the count of the people which they have to cater to the needs of. They have to determine their status. So all these refugees, when they enter into any other territory, they apply for an asylum in various countries, where they have a very well mechanized system of how to provide them with the asylum. So these asylum seekers, if fall under the category or under the ingredients which are required to be fulfilled as a refugee, they might be granted an asylum within the country. But again, I would say, if you look at the real picture, the governments, they do practice their discretionary power as to whether they want to allocate, or whether they want to accommodate a particular class of displaced persons within their country or not. Now, seldom when we talk about displaced persons, this terminology is seldom interchangeably used with the term refugees. While in reality, there are various different classes of displaced persons who are present on the global level. The Refugee Convention 1951, which is also the centerpiece of the legislative protection which is provided on an international level, it provides a very well-defined definition of who a refugee is. So refugees, they are not the same as the internally displaced persons, and again, the both of them are not the same as the stateless persons. So displacements are of various kinds. When we talk about refugees are the one, where again, where there is a well-founded fear of persecution, or who have already undergone a persecution on the basis of caste, sex, religion, of belonging to a particular community, a social community, a political community. They undergo persecution, and eventually, in the wake, or in the wake of chaos, they have to cross the international borders. So the very raison d'etre of the definition of refugee is that they have to cross the borders, the international borders. It is the movement of displacement is across the borders. While we talk about the internally displaced persons, these persons were such who were, from a very long time, though recognized, though, the lawmakers on an international level knew that such a population did exist, was majorly eclipsed by the protection mechanism so provided to the refugees. So, when we are talking about the protection regime which is provided to the refugees, let's say with the 1951 Refugee Convention, internally displaced persons were such that they were never recognized. At least on the papers, they were never recognized. They were always, majorly eclipsed by the protection mechanism of refugees. So much so, Eleanor Roosevelt, after the World War II, who was the major protagonist of, protecting and also formulating various documents concerning the human rights, she even quoted in one of her speeches where it was, hello, hello,
Yes, 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 yes. You can listen. Yeah.
am I audible?
Yes, you're audible.
Am I audible?
Yes, yes, you're audible. Yes.
Okay, okay, okay. So, yeah. So, where Eleanor Roosevelt, she even quoted in one of her meetings that, internally displaced persons, they are entirely different from refugees and they cannot be, placed under the same categories as that of the refugees. And hence, but, internally displaced persons, they were lately recognized under the 1998 guiding principles of displaced persons. So it is really a matter of dismay that it was only lately in the year 1998 that there were some guiding principles which came up, which aimed at protecting the internally displaced persons. So when we talk about the internally displaced persons, this is the category of those displaced persons who are displaced but who get displaced, who are uprooted or who deracinate from one part of the territory to any other part of the territory. They remain within the territory. They do not cross the territory. So the movement is not across the borders. It is within the territory. A very famous example is that of the Kashmiri migrants, the migration of Kashmiri Pandits that happened in the year 1991, where there was a religious genocide in Kashmir, and eventually all the Kashmiri Pandits, they were forced, they were compelled to leave their homes back there and settle elsewhere in the country. So we have their instances of being settled here in Jammu or maybe in Delhi or Bombay and elsewhere in the country, but their movement was within the country. It was never across the borders. So that is why they were called as the internally displaced persons. And then we also have the third category of persons who are also called as the stateless persons. Now, what happens when this displacement it takes place? Many a times, such situations arise where neither the receiving state nor the state from where these people have displaced are ready to accept such persons as their own. So they basically have no nationality at all in such a situation. Many a times it so happens that many people are rendered stateless, resulting which they do not have an identity at all, and they do not know where to go. But whenever such a dispute it happens regarding the stateless person, or wherever a person is rendered stateless, many such situations have been taken up by the regional courts of human rights or by the International Court of Human Rights. We I have a very interesting example in one of the cases of Tornado versus Tanzania. What happened was that the Tanzanian authority, the applicant, he had actually moved up to the African Court of Human and People's Right, where he contended that I am rendered stateless because the Tanzanian authority had cancelled his nationality, his citizenship, by virtue of contending him to misrepresent his identity before the authorities, and as a result of which he was deported to Kenya. And now when this person enters Kenya, this person was arrested by the Kenyan government for having an illegal entry in the country. So neither the Kenyan government nor the Tanzanian government was ready to accept him as his own national. Ultimately, the dispute arose, and they moved forward and before the African Court of Human Rights. Eventually, where it was decided that this person was rendered stateless because of the Tanzanian authorities who were not able to carry on the proceedings properly. So such situations also arise. So my entire idea of delving more into the definitions of these three categories of displacements was that displacements are not majorly only refugees. We have different classes of displacement, and we have different protection mechanism for the same. Now, as far as we are talking about the internal protection regime of the displaced persons, the internal protection regime of the displaced person, it started soon after World War II, because after the Second World War, again, there were so many displacements, especially in the Western Europe and then around the world as well. And the beginning of the new era, it happened after the Second World War, when the United Nations Charter came. Now, when the United Nations Charter came, thereafter came the other human rights treaties as well. We are all well aware. The UDHR came, and then we have the ICCPR, and we have the ICESCR, and all these human rights treaties, even though, they did not specifically exclusively talked about the refugees or the displaced persons, but they still contain provisions whereby they said that, the displaced persons or the refugees, they also have their rights. So their civil political rights and their social, economic, cultural rights were already protected in the initial teething human rights treaties. But it was only in 1951 when the centerpiece of the protection mechanism of refugees came up, and it was the Refugee Convention 1951. The Refugee Convention 1951, it entails in detail. And first of all, it gives a very comprehensive definition of who a refugee is. And then it entails in detail the rights which are protected of the refugees, which again, it talks in detail about the civil political rights, the economic, social, cultural rights. And, it also talks about the principle of non-refoulement, where it says, if a person is still having a fear of returning back to his own country from where he had come, he cannot be forced or he cannot be compelled to repatriate or go back to that place, because he still has a well-founded fear of persecution. So, a refugee convention in that sense is very important legislation or a very important legal instrument on an international level. And, for the implementation of the Refugee Convention 1951, or for the proper execution of this convention, and for other matters relating to refugees, in 1950 came the United Nations High Commissioner for Refugees, which is the UNHCR, or which can also be called as the parent body, which is responsible for the protection of the refugees all over the world. And while it is doing a commendable job all over the world, the major function of this organization is to determine the status of these refugees, to register these refugees, and again to see to it that, all the state parties, they are effectively carrying out the protection mechanism of the refugees, this being the major function of this organization. And with the Refugee Convention 1951 being the parent this thing convention or a legislation concerning the protection mechanism of the refugees, there were further various regional conventions which came up in different regions concerning the protection mechanism of the refugees. For instance, if we talk about the America, the Organization of African Unity, it initiated with a concerning the refugees 1969. But the beauty of this convention was that it expanded the definition of a refugee. It expanded it more number of refugees, where in the original definition as contained in Refugee Convention 1951, various parameters were not included as to who could be called as refugees. It was expanded by the OAU Refugee Convention in 1969, where even the refugees who were a product of decolonization, or the refugees who were product of the creation of a new state, or who were a product of an armed conflict, they were also, covered under the definition of a refugee. And if we talk about the Central American countries, we had the Cartagena Declaration, which came in the year 1984, again concerning the protection mechanism of the refugees. Now, the beauty of these regional, conventions is that these conventions, they formulate the provisions of their own conventions depending upon the issues of their particular area. the issues which their particular area which might not be covered under the Parent Refugee Convention 1951, they were covered under the regional convention relating to the refugees. So if we talk about Central America, it passed the Cartagena Declaration 1984, which again concerned about the protection, with Refugee Convention 1951 being the model or the parent convention. And then we also had the Bangkok Principle, which were accepted by the Asian and African countries. So India was also a part of it. And, again, they talk about the protection of refugee mechanism from Asian perspective or from an African perspective. So like this, we have this is to talk about the international protection regime of the displaced persons. At the same time, we cannot, ignore or sideline the functions of the global judiciary, because global judiciary has also been very welcoming, and it has been very encouraging as far as these refugees were concerned. So there were a number of cases which I have filed and which I found very interesting to share with all of you. One of them was this AA versus Switzerland. So this concerns an Afghan refugee. In this the Afghan refugee who had come from Afghanistan, and he had fled to Switzerland. Now he it was quite some time when he had fled to Switzerland. He was originally a Muslim personnel, so he faced persecution in his own country, that is Afghanistan, and he came to Switzerland. When he came entered Switzerland, he got himself converted into Christianity and eventually decided never to go back to Afghanistan. Now, on the contrary, the Switzerland authorities, they thought it best to repatriate him, because perhaps they thought that the situation in Afghanistan had normalized now, so it was time for him to go back. But when this matter was brought before the European Court of Human Rights, it was decided by it that this person is still fearful of going back and facing persecution in his own country, so he cannot be sent back. Another case was NA versus Finland. Again, a very interesting case. Here, it concerns an Iraqi personnel, a person from Iraq who again was facing persecution in his country. We know the amount of genocides and the amount of atrocities that are being done in Iraq, Iran, etc. So he was this Iraq personnel who had entered Finland, who had fled to Finland owing to the persecution that was happening there, the religious persecutions that were happening. So, Finland authorities again told him to go back. Now you can go back, you have to repatriate, etc. But this person was not ready to go back. And on being compelled by the Finland authority, he ultimately went back. But as the fate had it, he died there as a result of the genocide. Now, the family of the deceased, it came up to the European Court of Human Rights, and it said that our person was already saying that he never wanted to go back, and Finland authorities, they compelled him to go back, and as a result of which he had to die. So this was vehemently opposed by the European Court of Human Rights, and eventually, you know, it was decided, the Finland authorities, they were ordered to pay a hefty amount of compensation of 4,000 euro plus taxes to the family, along with 4,500 euros plus taxes to the family who had incurred the expenses of the court proceedings, etc. Another very important case was Peposhvili versus Belgium. And this was a very peculiar case because in this case, where a person had fled to Belgium from Georgia, so he said that I have leukemia. He was suffering from leukemia and also recurrent tuberculosis. And he said, in case I go back, I would be ill-treated there because of the problem that I have. So I don't want to go back. And at the same time, my entire family is here in Belgium. So I don't want to go back. If I part ways from my family, I might as well die. And to much surprise, European Human Rights Court was even welcoming to this, and it ordered the Belgium authorities that okay, no going back. He cannot go back because of the situation that he is talking. He might even as well die there. So, he was ordered to stay back in Belgium. And a similar case again in SSM versus United Kingdoms, again, where a person, who had certain mental illness, he wanted to go back, and the United Kingdom's authority were repatriating him. But again, the European Court of Human Rights, it ordered that no, you cannot go back because this person doesn't want to and doesn't feel safe of going back to his country of origin. So, by citing all these cases, what I am trying to tell you is that the judiciary on the international level is also very welcoming and very empathetic towards the refugees and the displaced persons, and it is at their rescue. It has served to be at their rescue for many times. Now, if we talk about the domestic protection mechanism, that is the protection mechanism that we have here in India. It is, as I told in the beginning, that we have a very ironical protection mechanism here in India. Because, India is a home to almost 2 lakh refugees. Many might not know it, but this is the truth that we are a home to almost 2 lakh of refugees. And it is not that India is not catering to their needs. India is catering to the needs of various classes of refugees, but depending upon its affinity to a particular community of the refugees or to the country from where they are coming. So India has a very ad hoc policy as far as the protection mechanism is concerned, because we have not ratified the Refugee Convention 1951 on the international level. So India does not find itself obligated on an international level to, provide shelter to every refugee who's entering India. And on the other hand, we do not have any legislative framework or a legal instrument which is, primarily only concerned with the displaced persons, as a result of which there is a legislative vacuum concerning the displaced persons in India. Now, if we the details and how then the entire process is mechanized, then how the entire protection mechanism takes place, that we are going to talk a little later. Before that, I would like to tell you the classes of refugees who are present here in India. So we basically have two classes of refugees who are residing in India. We have the mandate refugees and we have the non-mandate refugees. Now, what is a positive aspect is that even though India is not a party to the Refugee Convention 1951, it has allowed the setting up of the UNHCR office here in India. So we have two offices in India, one in Delhi and one in Chennai. So the UNHCR that stays in India, it carries out the process of the status determination of registering these refugees, or of the process of providing them with a durable solution of either resettling them or integrating them within India or repatriating them to from where they have come. So UNHCR is here in India. Now, when I talk about two categories of refugees, one is the mandate refugees, another is the non-mandate refugees. Mandate refugees are the one towards which or where India takes keen interest in this category of refugees, that okay, the central government is going to cater to their needs. It is going to take the responsibilities of these refugees. And as I mentioned, there are different classes of refugees. For example, we have refugees from Pakistan. From Pakistan, we have had various classes of refugees in the history, at various timelines in the history. In 1947, in 1965, then in 71, whenever we have had a dispute with Pakistan, we have always welcomed refugees who perhaps belonged to a particular community to which the Indian government had an affinity. In 1950, in 1947, after so many, when there was, a mass influx across both sides of the border, and there were so many non-Muslim population which had come here, and there was so much Muslim population which had gone across the border where, they found themselves safe and where they also had a cultural affinity. The Indian government had provided a proper mechanism of rehabilitating them, of, providing them with the immediate relief as well as with the permanent relief. At that time, after 1947, there were so many central legislations which primarily were meant for the displaced persons from West Pakistan refugees, or for the other categories of refugees who had entered India. They were even provided with um, compensatory lands. They were even provided with the immediate relief, the camps, shelter, homes. Everything was provided to them, whatever a country needs to provide or ought to provide to its refugees. Then we had another category of refugees who were the Bangladesh refugees, who again had to come to India after the 1971 war with the Bangladesh, or the formation of Bangladesh. Again, there were so many classes of refugees and displaced persons who had come to India, and again, and these were also called as the East Pakistan refugees. And again, India was there, all there to help them, to provide them with immediate relief, medical aid, with shelter, with food, and then eventually also provide them with housing and allowing them to, continue with their employments, and then integrating them, naturalizing them within India as their own citizens. And then we have a very interesting relationship with the Tibetan refugees. Tibetan refugees, they, entered India when there was a bilateral agreement, which was signed with their political as well as the spiritual leader, Dalai Lama. So when they had Chinese invasion before 1950, many of the Tibetan refugees, they had fled to India, and many had sought refuge immediately in Calcutta and West Bengal, because that was the border from where they entered India. And eventually, Indian government and the Dalai Lama, there was a bilateral agreement where eventually it was decided that these people, they were not only provided with temporary relief and compensations, but they were also provided with the permanent settlement here in India. So today, even though they reside in various parts of the country, a proper land was allocated to these people in Himachal Pradesh, in Karnataka, in Odisha. So we have a population of Tibet people who are residing and who are leading a very normal life, unlike the displaced persons, because they were provided with the temporary short-term as well as long-term visas. At the same time, they were provided with certain certificates which were, kind of their identity certificate, which allowed them to travel, which allowed them to carry out employment within the country, carry out economic activities within the country. And today, if you go to such areas, you would find that they are really progressing. They are really prospering because they were allowed to indulge into gainful employment. So they began with getting indulged in gainful employments like or small scale industries like weaving and in whatever in being the restaurant owners or in being the taxi drivers, and eventually their businesses have flourished and they have for instance in Himachal Pradesh we have a very famous hill station called as McLeodganj, which is managed entirely by the Tibetan population. And even though they are the displaced persons within India, they are quite flourishing, and they do not look like displaced persons at all. And then we have another category, which is also the Sri Lankan refugees who, time and again, had entered the southern parts of India and who had fled to the southern parts of India, and where, the Tamil Nadu government as well as the central government was always very welcoming for them. Because again, these people had some kind of cultural affinity with India, and India was ready to naturalize them or integrate them within their own territory and country. But and again, they were provided with every kind of facility, be it related to health, medical, food and nutrition, shelter, etc., housing and lands and employments, every kind of facility, education was provided to them. But it was only after the Rajiv Gandhi assassin, when it was found out that who the assassins were, there was a kind of hostile behavior of the central government towards this class of population, because again, they feared a threat to their country. And that is when a little attitude of the central government changed towards them. But having said that, the local government of Tamil Nadu was always very welcoming to them. Even today, it is quite welcoming to the Sri Lankan refugees who enter because of the cultural affinity. Now, if we talk about the non-mandate refugees, there are, other categories of refugees who have entered India, who from, let's say they are from Afghanistan, we have displaced population from Sudan, Somalia, Iraq, Iran, Myanmar, etc. Now these are the categories of population which are not very well acknowledged by the Indian government, I would say, or or perhaps the Indian government also chooses, to pay much heed to such population. Perhaps the Indian government doesn't have an attitude of integrating them within their own population. So such category of population is catered to by the UNHCR. And the UNHCR takes care of these population. And many a times, whenever there is a conflict regarding any kind of executive machinery in the country, or because of any lack of communication amongst the state and the center relating to their naturalization process or to their protection process, UNHCR comes to their rescue. And that is the one which serves as a messenger between the government as well as these people. So UNHCR is taking care of these people. And in addition to that, we also have various non-governmental organizations which are there to help various classes of refugee, irrespective of the class they belong to, whether they are mandate or non-mandate refugees. Okay, so having talked about the mandate as well as the non-mandate refugees, what we really need to understand is that we have a very ad hoc policy, which is managing these refugees. We do not have any particular legal instrument or a legislation which is concerning directly with the displaced persons. So where we do not, then the question that might arise in every mind is, then how are these people managed in the country? How are these displaced persons accorded protection? So they are accorded protection under the other legislative enactments that are present. For example, we have the Citizenships Amendment Act, or we have the Foreigners Act, or we have the Passports Act. So these are the legislations under which they are governed. But what is a matter of dismay is that these legislations are meant for immigrants, right? So if you are equating these refugees with the immigrants, you are that is the biggest kind of discrimination that is happening, because the needs of both the class of population is different. Where immigrants, they might be legal or illegal, whatever, but their situation in which they have entered the country is different. These are the people who have entered the country because of the exigencies that they were caught up in, or because of the emergency that they were caught up in, and of course they need various um, protection mechanism. So what happens exactly is that when a particular class of refugees, they come, or displaced persons, they enter India, what happens is their protection mechanism is dependent upon the discretionary power of the government under which they are entering, either the central government or the state government. For instance, we have a very famous case of NHRC versus state of Arunachal Pradesh, which we are going to discuss later as well. Where the Chakma refugees, they had about 65,000 Chakma refugees had entered Arunachal Pradesh, and the central government was ready to accommodate them, while the Arunachal Pradesh local government was not ready to accommodate them. And even the local population was very xenophobic towards them, and it was not ready to accept them as the citizens of India. As a result of which, they had to suffer, and their applications for naturalization process were not forwarded to the central government, while the central government was all there to cater to their needs. And as a result of which, they had to resort to the Supreme Court, and eventually it was decided by the Supreme Court that, okay, their rights under Article 21 cannot be taken away, so at least they have the right to live. And eventually it was also decided and directed by the Supreme Court that their naturalization process should be taken care of, and with the due vigilance. So there are such cases. And another thing is that when these refugees, they enter a particular country, they had to suffer because of the sporadic measures that are being adopted. What happens is, there is not enough communication between the central government and the state government. So for example, if some refugee is entering J&K, and there is not enough communication between the central government and the government of J&K, then who is to suffer? It is the refugee who's suffering, where there is not enough communication about the number of refugees who have come up, or where the forwarding of their application for the naturalization process is not there, or where proper communication is not made between the two governments. Who suffers at such an instance? It is the refugee who suffers. For instance, we have this case of Shah Ghazai versus the state. So this was the case which was concerning an Afghan refugee. So an Afghan refugee, he tried to run away from India, from the Atari border of Amritsar. Now, when he was trying to run away from that border, he was caught by the Indian authorities, or by the authorities of the Punjab, because again, that border is comes under the territory of Punjab. So when he was caught up there, he was taken to the asylum. Then the entire process took place, the court proceedings took place, and he was detained for a period of 1 year. So he was caught in 1994. So till 1995, this person was detained. But while actually his, entire tenure of detention had finished, because of the lack of communication between the Punjab government and the government which was at center at that time, this person continued to be in detention for 2 more years. It was only after this petition, was filed before the court, and eventually the court decided that no, this detention is unlawful, and he was ultimately freed. This person had to be in the jail, in the detention for 2 excessive years. So this is how these persons, sometimes these persons, when they are crossing the borders, let's say they are crossing the borders from the land, from the land borders, when they are doing the first person that they say face from the Indian system are the BSF personals. Now, sometimes, they might take them directly to the asylum where they would obviously interrogate about the person, and sometimes they are mistakenly taken as somebody who's posing threat to the country. And most of the time, trust me, most of the times it is so that happens. If only if, the central government, it forwards the communication that, okay, such and such people are coming and you have to accept them. That is when the BSF is going to accept them. Otherwise, obviously, it is not going to accept them as, or it is not going to welcome them with the arms wide open. So, because of the non-presence of any particular legislative enactment, which is, catering to the needs of the displaced persons in India, and which actually has a uniform treatment towards every kind of refugee, irrespective of the background that he comes from. These people would always suffer, and many a times it so happens in India. So, this is what I've talked. And now let us also shift to the Indian judicial approach towards the displaced persons in India. So, judiciary has been quite welcoming as far as these people were concerned, and it has always had a very empathetic attitude towards the refugees. So if you talk about this, again, I discussed this case NHRC versus state of Arunachal Pradesh, which concerned the Chakma refugees who were wanting to, integrate within India because of the situation that they had in Myanmar. These were the Myanmar refugees, So there was this Hydel power project because of which these people got displaced, and ultimately they had nowhere to go, so they came here in India. They crossed the borders of India, and when they came here, the local population was not ready to accept them. So while the central government said that, okay, we are ready to entertain the applications for the naturalization process, the local government was not ready to do that. So, the district collector who was responsible for forwarding the application of their citizenship or for their naturalization process, he never did so, as a result of which, their entire process of naturalization was delayed. So eventually they went to the Supreme Court, which again gave the direction, and that is how they got a little relief. So this is what was decided in NHRC versus State of Arunachal Pradesh. We have another case, which is Chairman Railway Board versus Chandrima Das and others, where again, this issue of the protection mechanism of any alien or of a displaced person came up, and it was very explicitly and outrightly laid down by the Supreme Court that, okay, I cannot speak about other rights, but at least the right to life, which is entailed under Article 21, was, available even to the non-citizens or the aliens in the country. So, it was not only available to the citizens, it was also open for the aliens. And then it also made reference to the ICCPR and ICESCR, to which, Indian government is today also a party. So it says that it definitely has an international obligation under such treaties, even though it is not a party to the Refugee Convention 1951. It is a party to other conventions which are concerning the human rights, and, so India cannot shy away from its duty of entertaining these people and catering to their needs. Then we have another case of AC Muhammad Siddiqui versus Government of India. Again, in this case, there was this, it was decided by the Madras High Court, where there was this Sri Lankan refugee who never wanted to repatriate, while the Indian authorities wanted to repatriate him. And eventually it was decided by the court that, because he still has this well-founded fear of persecution back in Sri Lanka, you cannot force him to go back. So the principle of non-refoulement was contained in this, and it was protected. We have already discussed the case of Shah Ghazai versus the state, which again concerned about this Afghan refugee who was trying to cross the border of Amritsar, and eventually, he was detained for 2 excessive years. So these are the kind of cases that come up before, the Indian government, because of the lack of effective legislative mechanism for the protection of these people. Now, as far as the NGOs are concerned, NGOs have been quite active in providing help. So wherever the gaps have been left by the Indian government or by the central governments or by the state government, these NGOs have always come up at the rescue of various classes of refugees who were residing within the country. For example, we also have the setting up of various international refugees like the ICRC or the Human Rights Watch or the Jesuit refugee services, who, primarily aimed at providing refuge and providing immediate relief, rehabilitation, education, employment, etc., etc., every kind of facility to the displaced persons. They do so in consonance and in collaboration with UNHCR, because UNHCR is also actively involved in India that ways. And then we also have certain national NGOs, like we have the Socio Legal Information Center, SLIC, which concerns about the social aspects of these displaced persons. So it has social counselors to cater to the needs of their mental instability or the mental trauma which these refugees go through, to provide their children with education, to provide with every mechanism or every kind of provide them with a platform where they can be employed, and otherwise also, if they have, if they're caught up in any kind of conflict with the governmental authorities or otherwise, to provide them with a legal representation before the courts of law. So this is the major function of this national NGO. Then we have another NGO, a very famous NGO, which is also the Voluntary Health Association of Delhi, which primarily concerns about the health of these persons. So it concerns about the chronic ailments. Medical aid is provided to them, not only for chronic ailments, but also for non-chronic problems that these refugees might face. So this is another NGO. And then we also have the Young Men's Christian Association. Again, it is very deeply involved with, providing these refugees with immediate refuge, shelter, clothing, medical aid, health, food, nutrition, etc., and also with the long-term, benefits, like it has, for instance, of that. The long-term benefits like that of employment, or providing them with education, or helping them with the naturalization process, etc. So, these NGOs have also played a very significant role in collaborating with the UNHCR and, bringing these people at par with the citizens as far as they can. Now, what are the obstacles of the protection of the displaced persons in India? The first major obstacle is that India is a non-signatory to the Refugee Convention 1951. The reason which India gave while, were deciding not to sign or not to ratify this convention was that it believed that the Refugee Convention 1951 was a very Eurocentric convention, which had a very uniform norms laid down for the protection mechanism of refugees, and sidelining the turpitudes which the developing countries are facing. And another reason which it gave was it believed that the Refugee Convention, was more centric towards, or it, focused more on the obligations of the receiving state, while the state from which these countries had come, or the which are also called as the states of their habitual residence, they were not told about their obligations, or their obligations were not much focused upon. So, by virtue of giving these reasons, India decided, not to ratify the Refugee Convention 1951. As a result of which, many a times, India, shies away from its obligation of catering to the needs of a particular class of refugees. And then we also have in the UN Charter itself, there is this Article 2, Clause 7, which is the non-intervention clause, which says, yeah, when we are talking about the international jurisdiction of any particular, let's say, conventions, or of any particular bodies, their international jurisdiction cannot cross or cannot intervene in the domestic jurisprudence. This is what is provided in Article 2, Clause 7. So, by virtue of this clause as well, many a times internationally, the United Nations has tried to, intervene in our matter. For example, in case of Kashmiri Pandits, it tried to intervene, but India was not very happy with its intervention by taking the defense of this article, which is Article 2, Clause 7, which talks about the non-intervention of the international bodies in the domestic affairs. So this is another impediment which comes in way of the protection mechanism of, or which comes in way of, the international bodies interfering in the Indian domestic affairs. And the biggest flaw in our system is the lack of any codified laws concerning refugees or displaced persons in India. The day we have a displaced a codified law which is specifically concerning the refugees or the displaced persons in India, all the other legal gaps, all or all the other lacunas that are present in the present protection mechanism of refugees in India, they would come to an end. Because when we are equating these displaced persons with other immigrants under the normal legislation, let's say the Citizenship Amendment Act, or let's say the Other Foreigners Act or the Passport Act, we are not catering to the immediate needs these displaced persons might as well have, because it is not only the naturalization process that these displaced persons come up with, that is, to be catered much later, but in the process, there are so many other needs which need to be catered for these displaced persons, for which we do not have a very demarcated, law, or we do not have a codified law. So, just in case if we have a codified law concerning the refugees, there would be a uniform practice of protection of displaced persons of any category of displaced persons entering India, irrespective of the community that they are belonging to, or irrespective of the country from where they are coming, and irrespective of the government which is at the center. So I think that there needs to be a codified legal instrument, at least within the country. If India cannot, ratify the Refugee Convention on an international level, at least we should have a, different convention or a different codification of law or a legal instrument concerning the protection of displaced persons in India. And again, the non-uniform political bias towards different classes of refugees, as we've already discussed, that there are different classes of refugees which exist in India, the mandate and the non-mandate, and there is a category of mandate refugees for which the Indian government takes the responsibility, while there are others for which the Indian government is not much interested. So in such a case, there is a bias. Sometimes, the whatever government is at the center, it might definitely have a bias towards a particular kind of community, which in future, might serve as its vote bank, or for the inclination of a demography in a particular, in favor of a particular community, which ultimately is going to serve as its vote bank. This is discriminatory in its very nature. If we talk about the latest Citizenships Amendment Act, which has come, and the much controversial Citizenships Amendment Act, where, in the very provision, it has been mentioned that India is going to cater to the needs of only, a particular communities which are mentioned in the act, that is the non-Muslim communities, and it is ready to welcome them from the countries of Pakistan, Bangladesh, and Afghanistan. So it is trying to actually create a divide on the basis of religion, which is opposed to the very basic fundamental of the constitution, the basic article of Article 14, that is non-discrimination. And if we talk about the similar provisions in ICCPR, UDHR, ICESCR, there cannot be discrimination on these grounds. So this is actually very alarming situation for the country, because you are favoring a particular class of refugee or a particular community, and you are not favoring any other community in the country. So this actually poses a lot of threat to the country. So I think that the political bias would also end if we have a legislative enactment in the country, which is going to lay down uniform standards for every class of displaced person, irrespective of the community or the place from where they come from. So that brings my entire this thing lecture to the end. So if anybody has any questions, any queries, I am all there to answer you. So let us see.
Yeah, thank you very much, Dr. Priya. We have some. Yeah, Pooja, Lakshmi, over to you.
Dear participants, please raise your hands. We have our Sanskriti raised her hand. Please unmute yourself.
Good evening, ma'am.
Oh, hi.
Hello, ma'am. Ma'am, actually, my question is that like new laws has been implemented for CRPC, IPC. So, like these new implemented laws have any change in the pre-existing laws for refugee, or any new amendment is there in that laws?
Okay. So, when we talk about the criminal laws or the IPC or the CRPC, these are primarily meant for the residents of the country. So that is why I say that, even if you want that a particular refugee or a particular displaced person who is residing here in India, you think that he has done any kind of offense staying here in India, if we have a separate legislation which also entails this provision as to what would happen with such a scenario, in such a scenario where he commits crime, it would be more, I would say, comprehensive, and it would be more clear as to what has to be done with such a kind of criminal offender. Otherwise, to pick up any such display, because such practices have also been happening where, a particular displaced person is belonging to a particular community, and because the Indian government doesn't have an affinity, I'm not talking about any particular government, but any government, it might not have any affinity with such to the community that he belongs, and he is put behind the bars, unnecessarily, and taking the help of these IPC or the CRPC, which is present here, and any kind of forging and any kind of distortment of these laws is possible. But if we have a legislative mechanism which also lays down as to what would happen with such a criminal who is a displaced person, would he go back to his place of origin, would he stay in India, and be proceeded with, that really has to be dealt with, that has to be taken care of. Thank
Okay,
you.
ma'am. I hope there are no hand raised. There is a question in the chat box. May I read it to you, ma'am?
Yes.
Owing to geographical limitations, how far it is justified to give shelter and protection to refugees or stateless persons in India?
Could I also read this question? Just a moment.
Okay. This is sent by Amrita Anand.
Okay. Owing to geographical limitation, how far it is justified to give shelter and protection to refugees of stateless persons in India? If we talk on, on humanitarian grounds, I think that whenever a person is stateless, is rendered stateless, and no nation is ready to accept such a person, it is, never a bad idea to give shelter to such a person. And ultimately, what the fate of such person is going to be, decided by the international court, because courts or the regional courts, because the nature of the problem is such that it is international. It cannot be decided by the domestic courts of our country. The nature of the problem is that two nations are involved. So it definitely has to be decided by a regional court or by an international court. But it is justified to give shelter. Given that such a person at the same time is not posing threat to the country, or is not a terrorist, or or any kind of a threat. Sometimes many stateless persons or many refugees, they are not entertained by a country because they come and they create they are responsible for causing so many offenses or criminal crime in the country. So it is justified, but at the same time, other parameters also have to be looked into or taken into consideration. Yeah.
Okay, ma'am. Thank you, ma'am. Is there anyone else with a question? Please put it in the chat box or raise your hands.
Are there any more questions?
Participant, any last question? We have a few more minutes. So,
They,
Anisha, I think Anisha, you are raising hand, or I don't know.
is she raising her hand or is she bidding goodbye to?
Yeah. Yes, Anisha, you can
Hello.
ask.
uh,
हाँ बोलिए, yeah, please, yeah.
Yes, good evening, ma'am. Ma'am, my
Hi.
question is, for an example, like two kids and one woman are walking on a street, right? And there is a accused who tried to sexually assault or sexually exploitation and tried to attempt a rape on a minor. In that case, if a mother tries to like escape from that situation and somehow like she has beaten the accused, which badly she harmed him and gave him a grievous hurt. and even she naked him and made him walk on the road. So in this case, can the accused take the protection from the human rights, stating that someone has played with my modesty or something? In this case,
And
what
in
would be the
case,
cause?
and in this case, the mother is a displaced person, or is she the resident of India?
Is a resident of India, and this incident took place, and in her safety, she has done this.
No, so there is no question of displacement anywhere in this question. Is there anybody who belongs to a displaced population in this entire episode? Or is this just a normal question concerning human rights?
It's related to human rights, ma'am. So that accused will get the safety from the human rights for for coming out from this case, that I have been getting a grievous hurt, or
Okay, okay. Yeah, Anisha. So in there are plethora of such cases that happen in our country at so many moments. And
Mhm.
again, in our country, the major protector of human rights is, if you talk about judicially, is the judiciary. So you can definitely go up to any court, whether it's the lower court, the trial court, or to the high court, or even to the Supreme Court if required, and you can file a case against such a person, and this is like a case of sexual harassment, or attacking the modesty of any woman. So it can be done. So there are plethora of cases and plethora of such situations that happen, uh, I think, every day in our country. So it can be done. And the greatest protectors of human rights in our country is our judiciary. So you can always go up to the judiciary, which is there to protect the human rights, which are entailed again in our constitution and in other enactments.
Yes, ma'am. But I wanted to know, in this case, being an defaulter or being an accused, and even he's the even police knows that he's the accused culprit. Can he get the can I speak in Hindi, ma'am?
Yeah, why not? Please.
ओके मैम, फॉर एग्जांपल वो अक्यूज जो है, अगर उसको बचना है, उसकी गलती के लिए अगर वो बचने के लिए ह्यूमन राइट्स का अगर सहारा ले रहा है, भले उसकी
Hmm.
गलती उसने किया है, बट
Hmm.
स्टिल, तो क्या उसमें ह्यूमन राइट्स उसकी मदद करेगी?
देखिए, दिस इज फॉर द कोर्ट टू डिसाइड, बिकॉज ह्यूमन राइट एसोसिएशन को अगर आप फोर्स्ड इंफॉर्मेशन दे रहे हो कि भाई मेरी कोई गलती नहीं थी, सिचुएशन ऐसी नहीं थी, मैंने उसको नहीं अटैक किया, परहैप्स ह्यूमन राइट एसोसिएशन और एनी एनजीओ विच इज प्रोटेक्टिंग or claiming to protect right, might go to the trial court. It is a matter of trial. And again, वहाँ पे trial पे जाके how the evidences are put up, and in whose favor the evidences go, eventually what the court proceeding is, that is all for the court to decide. That is all for the trial to take place. I hope you understand.
Yes, ma'am, I got your answer, ma'am.
Yeah,
Thank you, ma'am.
thank you. Okay, so there is another question. Considering the diversity in our country and the cultural conflicts, how far it is feasible to seamlessly integrate the refugees from different countries into our society? So, as I have already also mentioned in my lecture itself, that there are refugees who have been integrated in the country. If I talk about Jammu and Kashmir, there have been so many instances where these refugees, they were catered to, and they are. If I talk about myself, in fact, I belong to a family of refugees. So I was integrated. My family was integrated because we were given a help by the national government and the central government. The only problem in our country is that there is a bias towards a particular class of refugee or a particular class of community, in contradiction to other classes of refugees. That is the only problem, because otherwise, if you look at the history, there have been so many cases where such people, even belonging to different diverse cultural backgrounds, they have been integrated in the country. So I don't think it should be a problem. It is feasible. And as far as the another question, which is what is the status of the Tibetan refugees in India is concerned, I have already mentioned it in my lecture. And if you want me to delve more into it, I would say, there has been a bilateral agreement which has been signed with
Okay.
the political and spiritual leader of the Tibetan refugees. And there they have been, as I have already mentioned, they have been provided with all the permits. They are residing in Himachal Pradesh and Karnataka and Odisha, and they have been provided with lands by the central government, and the central government is all there to help them. So they are also getting involved in the economic activities in gainful employment, and now they have quite prospered, and they are residing like the normal residents of India. Yeah.
Okay, ma'am. With that, I guess all the questions are answered. Now, I would like to invite Yahya sir to give the vote of thanks. Over to you.
Okay, thank you, Pooja. Uh, Thank you, Dr. Priya Gupta, ma'am, for today's session on human rights. I hope that all our participants would have benefited from the session. So we will again have a meet for tomorrow's session at 5 p.m. Till then, have a goodbye.
Okay, thank you.
Thank you.
Thank you,
Yeah,
ma'am.
thank you, Dr. Priya. This is, I would say, first time I'm listening to this content. So let me tell you on the front.
I
It's a good
told you
test.
there is a lot to discuss on this.
Yeah, sure. Thank you.
Thank you.
Thank you.